Jason, thanks for being with us. This is a disturbing case that has left 100 foster children without finances and forced some of them onto the street without food or shelter. How did this happen?
It's an extremely disturbing story. A rogue social worker, Robert Riley Saunders, forged a bachelor social work degree from the University of Manitoba in 1996. Got himself the Ministry of Children and Family Development. And in April of 2001, transferred to Kelowna, and in 2002 was appointed to the Aboriginal High Risk Services Division of the Kelowna office. So that's, over the course of 17 years, placed 102 children in a very vulnerable spot. 85 of the children were Indigenous. So he neglected their background, their Aboriginal culture and language and spirituality, and disconnected them from their bands and their Indigenous groups and their family structures. So that was a primary tragedy, very similar to the 60s scoop in structure, but done on a smaller basis, in a much more abusive.
So police are still investigating. There haven't been any charges laid yet. Why did you go ahead with a civil suit?
Well, to my mind, it's foolishness to wait for the RCMP to investigate Aboriginal harms to Aboriginal people by government agencies. The RCMP has been notoriously derelict in conducting such investigations, in my view, in my personal view. So there's no real reason to wait for the civil claim. And in many senses, the civil claim is better at getting to the core of the issues, and certainly better at delivering compensation to individuals who are affected.
Well, thanks to that work, a financial settlement is being proposed for the children. What can you tell us about the details of that?
Well, it comes in two parts. The first is a basic payment, or a set of basic payments, for Indigenous children who were in Riley Saunders' care or at his mercy for a period of greater than 90 days before they turned 19. After April 1st, 2001, those class members will receive payments of $69,000 without showing any proof of loss. So there's a list of class members that's already generated. Any person believes themselves that they should be on the list, but they are not. There's a simple application form to apply for that process, and their eligibility will be determined by two adjudicators, lawyers in British Columbia, Haley Bruce and Ardith Wacom, who enjoy a high level of trust in the Indigenous community. The second part of the settlement involves determinations of elevated damages. So for class members who suffered sexual exploitation or sexual assault or homelessness, or their education was delayed, or they suffered physical abuse, or otherwise are experiencing symptoms, psychological harm like self-harm or substance use disorders, there'll be a process to apply for elevated damages. Again, the eligibility will be determined by Haley Bruce and Ardith Wacom, and the process will be as favorable and non-adversarial as possible for class members. So there's not going to be cross-examination, there'll just be questioning. It'll only be the adjudicators who can ask questions. The province of British Columbia and ministry can only suggest questions. The aim will be to avoid questions altogether and have the decisions made on the basis of the paper record without any need to interview the class members. So it's designed, the process is designed to avoid re-victimizing children who have already been traumatized by Riley Saunders.
Jason, we'll have to leave it there, but appreciate you taking some time for us here.
All right, well, thanks for following the story, and If any class members are listening, feel free to contact my office to get more details.